An undertaking is a very formal promise, usually in writing, by a legal practitioner to the court or to another legal practitioner. However, undertakings are used in some other types of legal proceedings. This is one of those cases. Evenco was a building company, and the Builders Labourers Federation, the BLF, was a union representing building workers. There had been a dispute between Evenco and the BLF in the late 1980s, and it was resolved by the BLF giving the court an undertaking in the following terms: to refrain from doing any act having the object of directly or indirectly preventing or hindering the servants or agents of the plaintiff, or such building construction workers as the plaintiff may assign from time to time, from entering upon any building site situated in Queensland, and from carrying out their lawful employment thereon, provided that the principal contractor on such site has been notified thereof and has made no objection thereto. By modern standards, this is fairly poor legal drafting with all of those thereofs and theretos. After some time, Evenco formed the view that the BLF was breaching its undertaking, and it sued to enforce the undertaking. The defence of the BLF was based on the idea that the undertaking was ambiguous in its terms, particularly in terms of the meaning of lawful employment, and that no undertaking could be enforceable unless it could be understood simply by reading the undertaking itself. Justice Williams agreed with the argument that it must be possible to understand an undertaking in its own terms. He quoted an earlier High Court judgment which said, "Those who give undertakings to a court are bound by the language they use. If its true meaning can be ascertained according to ordinary rules of construction, then the person giving the undertaking is bound by it." He then said, "Here the true meaning is readily ascertainable by applying ordinary principles of construction, and that meaning is confirmed by a consideration of the matrix of facts in which it was given. That meaning is so obvious, it must have been in the contemplation of the BLF at the time the undertaking was given." From this case, we learn that we ascertain the meaning of an undertaking by using normal principles of construction within the relevant matrix of facts surrounding the undertaking. The same rule applies to undertakings given by solicitors.